Right.
Hello, good evening, everyone.
Good evening, sir.
Good evening, sir.
Good evening.
Good evening, sir.
So there are two new students in the class. One is Farzana and one is Saloni.
Yes, sir.
Okay. So Saloni, we have done two classes of science and tech, and we started with these IPR issues. So you can watch the downloaded, that recorded videos. Okay. If there is any doubt, you can ask me anytime, or you can
Sir, I've
ask.
already gone through the videos.
Okay, that's good.
Yeah, and I've made the notes as well.
Okay, that is very good. And still, if you have any doubt, you can ask your queries. Okay.
Yeah, sure.
So yesterday we were talking about the dispute resolution. Do you have any doubt up till now?
Sir, I have a doubt in patents.
Yes, please.
Sir, in the role of IP protection regime, you gave an example of cancer drug,
Yes.
right? And while explaining the patent itself, you said that patent is basically related to industrial design, innovation, or technology.
Yes, I said that.
Yeah. So in the example of cancer drug, so will that be included in patent right?
Yes, because you are doing research and development to produce a new medicine. Okay. You are doing research before it, before arriving at a formula. That is some kind of innovation and technological innovation. Okay.
Okay, sir. Okay.
Because it is related to science. Okay. Biochemistry, biology.
Okay.
That is why it is treated as an innovation.
Fine, sir.
So yesterday I told you that India has passed certain laws for the protection of intellectual property. Okay. Every country passes certain laws for the protection of intellectual property, and the laws that are passed by India, these are the Indian Patent Act of 1970. We have the Trademarks Act of 99, the Designs Act of 2000, Copyright Act of 1957, and Geographical Indication of Goods Act 1999. So you have to remember 3-4 of them so that you can directly use them in the mains examination. In your mains answer writing, if you will use these some substantiable facts, then that will help. That will add edge to your answer. Okay. In the prelims stage is the most unpredictable. And I have told you that 98% of the students, they fail in this stage, and they fail in this stage because of the very stiff competition. UPSC deliberately sets up people which is very unpredictable, so that the 98% students get eliminated and only 2% students they pass through it. So there is a certain different kind of strategy to pass the prelims. The syllabus for both pre and mains, it is basically 75% same, and in mains we have the additional part of world history, ethics. Okay, we have some additional subjects, but basically the syllabus is the same. In the mains on the other hand is very predictable. Whatever be in news, 60 to 70% of the paper, it will be asked from the current affairs, the application of the concepts that you are learning in polity, in economy, in geography, or be it in science and tech. So all of the questions, they will be related to the current events. So that is why you have to make a habit of learning the case studies and learning some of the laws which you can mention in your answer. Okay. And while you are studying, you can adopt two strategies of studying your syllabus. One strategy is you can adopt the daily targets. Okay, you can set daily targets for yourself. आप डेली टारगेट सेट करेंगे कि आज के दिन में मुझे पॉलिटी के एक चैप्टर करना है, 2 चैप्टर करना है, इस तरह के टारगेट्स होंगे. ओके, एंड अचीव दोस टारगेट्स. एंड सेकंड स्ट्रेटजी इज टाइम पार्टीशनिंग. टाइम पार्टीशनिंग मीन्स इफ यू हैव डिसाइडेड कि डेली मुझे 2 घंटा पॉलिटी को डिवोट करना है, 2 घंटा मैं हिस्ट्री को डिवोट करूंगा और 2 घंटा मैं इकोनॉमी को डिवोट करूंगा, तो ये टाइम पार्टीशनिंग है. यहाँ पे स्टार्टिंग में क्या होगा, जब आप टाइम पार्टीशनिंग करेंगे, टाइम पार्टीशनिंग से आपके ऊपर कोई बर्डन नहीं आएगा. ओके, इफ यू हैव सेट अ वेरी हाई टारगेट and you fail to achieve it, then you feel depressed. So there are some issues with daily targets. If you have set some daily targets for you and you fail to achieve them, then it causes some kind of depression. Okay, so you can adopt any of the strategy, be it the daily target setting or be it the time partitioning. So yesterday I told you, because India wanted to attract the FDI. What is this FDI?
You are now unmuted.
Direct investment.
Yes, foreign direct investment. Basically, the foreign companies, what they will do, they will bring their technology to India. Okay, once a company comes to India, it brings its innovation along with them. So India wanted to attract the FDI. And also for the same reason, to attract FDI, India wanted that their ease of doing business rank, that should improve. Okay. And for that reason, the foreign companies, they had a perception that Indian IP regime, it was not very robust. India has laws to protect the intellectual property, but the enforcement mechanism, that is not very strong. Okay, you understand by what I mean by the enforcement mechanism? See, we have courts in India, and we all know that the cases, they drag on for year and year. Okay, they drag on for many years, for 10-20 years. Yes, Nikhil?
Sir, if we see example of some cases, sir, they will keep dragging.
Sorry, Nikhil, you are not clear.
No, sir, if we see some cases, sir, like in case of harassment or something like that, they will keep dragging that cases.
Yes, yes. So that is why the international community, they were not having faith on the Indian courts. Okay. So they want a robust dispute resolution mechanism. If there is a dispute between the two parties, if one party A has dragged another party B to the court, accusing party B that they have violated their intellectual property rights. Okay, then that case, it should not be dragged for years. They want a speedy resolution. That is what is meant by a dispute resolution. So for this reason, in 2015, the government of India, the Parliament of India, they passed a law, which is the Commercial Courts, Commercial Division, and the Commercial Appellate Division of the High Courts. So this law was passed in 2015 by the Indian Parliament. And by this act, the 3 things were established. One was the district commercial courts. Okay. And the second thing was the commercial division with the High Court. So we have a commercial division with High Courts. And apart from the commercial division, we have a third thing. We have the commercial appellate division with the High Court. Okay, so there are 3 things that are established by this act. One thing is the district court, okay, at the district level. And the second thing is commercial division with the High Court. हाई कोर्ट के अंदर दो चीजें हैं, वन इज द कमर्शियल डिवीजन एंड वन इज द कमर्शियल एपेलेट डिवीजन. ओके, सो दीज आर टू थिंग्स. एम आई क्लियर? यहां पे किसी को कोई डाउट अब तक?
Clear, sir.
Yes, Aman. Yes.
Clear, sir.
Yes, Aman asked.
Sir, I'm saying it's clear.
Okay, okay, fine. So for the purpose of dispute resolution, the Indian Parliament has passed this act, and under this act, three kind of courts they were established. One is the district court, and one is the commercial division with the High Court, and one is the commercial appellate division with the High Court, especially for the purpose of dispute resolution of these commercial disputes or the IPR type of disputes. So these district courts, the power to establish district courts, it is with the state government. See, सेंट्रल गवर्नमेंट ने एक लॉ पास कर दिया है और लॉ के अंदर उन्होंने लिख दिया है कि अब ऑथोरिटी स्टेट गवर्नमेंट के पास में. स्टेट गवर्नमेंट अगर चाहती है तो वो एक डिस्ट्रिक्ट कोर्ट एस्टैब्लिश कर सकती है बाय वे ऑफ नोटिफिकेशन. अब कोई सेपरेट लॉ पास करने की जरूरत नहीं है, बस स्टेट के ऑफिशियल गैजेट में वो नोटिफाई कर देंगे कि अब से इस डिस्ट्रिक्ट के अंदर एक कमर्शियल कोर्ट होगी. ओके, आई होप दिस इज वेरी क्लियर. So state government has the authority whether they want to establish a commercial court in a district or not. And the commercial division with the High Court, the power to establish the commercial division with the High Court, it lies with the Chief Justice of that High Court. Okay, so the Chief Justice of the High Court will decide whether he wants to have a commercial division in the High Court or whether he wants to have the commercial appellate division in that High Court. That power lies with the Chief Justice. Okay, and there is one more thing. When the state government establishes the district court, they have to consult the Chief Justice of the High Court concerned. Okay, the Chief Justice of the state High Court, his opinion will also be taken while establishing the district courts. Okay, so this act established the commercial courts at the district level, and there is a commercial court division with the High Court, and the third thing is commercial appellate division with the High Court. Okay, that will be established by the Chief Justice of the High Court, and this act provides stringent timelines for dispute resolution. So if there is an appeal, suppose there is a case, there is a dispute that is with the district commercial court, and district commercial court has passed a judgment, and after that judgment, suppose the dispute was between party A and party B. Yes, Harsh? Harsh wanted to ask something. Okay. Suppose the commercial court at the district level has passed a judgment for the dispute between A and B, and the party B, it did not like that judgment. So the party B can go to the appellate division, commercial appellate division, against the decision of the district court. So this commercial appellate division, the appeals in the matter of commercial disputes, they lie with the commercial appellate division. अगर किसी पार्टी को जजमेंट पसंद नहीं आया तो वो कमर्शियल appellate division में जाके अपील करेंगे against the judgment. Okay, so this commercial appellate division, it is bound by law to dispose these appeals in 6 months. So that is what is meant by the stringent timeline. So stringent timelines are provided. Commercial appellate division, they have to dispose of those appeals within 6 month time. Okay, this is mandated by law. That law of 2015, which is the Commercial Court, Commercial Division and Commercial Appellate Division Act. Under that act, it is provided the appeals have to be disposed within 6 months. I hope it is clear.
So what is the function difference between the commercial division and the commercial appellate division of the IPR?
See, in the appellate division, only the appeals will be filed in the appellate division. Okay, appeals against the judgments that were passed by other courts, other lower courts.
Yes, sir. And in commercial division?
See, you must have heard something like original jurisdiction. In some civil matters, the high courts have the original jurisdiction, in which cases the party can directly go to the court. Okay, so the commercial division can hear the cases, commercial disputes in the first instance. The commercial division, okay, it will also hear the cases.
Okay.
In polity, you will read that there is. Have you read about original jurisdiction? See, original jurisdiction means in the right to hear the cases in the first instance. So there are some certain kind of civil cases which can be directly heard by the high court. Okay, so this commercial division, it can take up those cases. Otherwise, for the smaller cases, what is the procedure? First, you have to go to the district court, and if you are not satisfied, then you will go to the high court. Like in the case of fundamental rights, understand this, in the case of the fundamental rights, there is no one stopping you from going to the Supreme Court. If your rights are violated, you can directly go to the Supreme Court. You don't have to go to the high court, you don't have to go to the district court. Okay, you can directly go to the Supreme Court. That is why fundamental rights, they are very important. You must have read it in polity.
Yes. Yes.
Okay. So similar thing is here. If there is a commercial dispute of certain degree of certain value, then that commercial dispute can be directly heard by the high court. So that is why there is a commercial division with the high court as well. Okay, that is a matter of polity, but here we are dealing only with the dispute resolution and the dispute resolution mechanism. So in the last year, the maximum number of cases that were filed, they were for the trademarks. This is some data. The maximum number of cases, they were filed for the trademarks, followed by copyrights, and then for the patents. So after the passage of this Commercial Disputes Act, there is an increase in the number of cases being filed in the court. So this is signifying that people now have faith in the dispute resolution mechanism and they are now approaching the courts. Okay. Stringent means सख्त punishment एक तरीके से, a punishment of higher degree. Stringent means something strict timelines. Is it clear?
Yes, sir. Thank you, sir.
See, Aman, we cannot set a timeline for the commercial courts, okay, to pass a judgment. It depends on case by case basis. Okay, so cases have different nature and we cannot give a timeline. Okay, you have to resolve this dispute within this timeline. Appeals, there is a different matter with the appeals. When appeals are filed against the cases, then they can be disposed of. Okay. So for the speedy trials, the government has taken certain steps, and one of those steps is the training of judicial officers, because the commercial disputes, they are technical in nature. Okay, they have to study the patent law and they have to understand the nuances involved with the technology. Okay, so technology, ये जो normal judges हैं, वो पेटेंट लॉस को शायद उतने बेटर तरीके से नहीं समझ सकते हैं. गवर्नमेंट ने ये रियलाइज किया और इस रियलाइजेशन के बाद में दे हैव स्टार्टेड द ट्रेनिंग प्रोग्राम्स फॉर द जुडिशियल ऑफिसर्स. ओके, So we have now the training programs for the judicial officers where they will be given training about the nature of commercial disputes. Okay, how to approach the commercial disputes, or we have the Patent Act and the other acts. So how to deal with them. So that is why training is necessary. So there is a sensitization and training program on the intellectual property for the High Court and District Court judges. And this training program, it is run jointly by WIPO plus the Government of India plus the National Judicial Academy of Bhopal. So a joint program is run by these three agencies where we have the World Intellectual Property Organization, we have the Government of India, and we have the National Judicial Academy, which is located in Bhopal. So, and the headquarter of WIPO is in Geneva, Switzerland. Does WIPO comes under the United Nations? WIPO is a separate body, or it is a body under the United Nations? Subhajit is saying no, and now he is saying yes. See, WIPO is a specialized agency of United Nations. United Nations have many specialized agencies, and one of those agencies is WIPO, World Intellectual Property Organization. Example of other agencies are like the Food and Agriculture Organization. Okay, we have the WTO. So these are some of the agencies of the United Nations. We have UNESCO. Okay, and similarly we have this WIPO. And the government is represented by this CIPAM, which is the Cell for IPR Promotion and Management. See, this CIPAM, it is a professional body. It is a professional body of Government of India, and it is also under Ministry of Commerce. Yes, Disha.
You are now unmuted.
So under the Ministry of Commerce, we have the Department for Promotion of Industry and Internal Trade. And under the same department, we have this CIPAM, Cell for IPR Promotion and Management. So this training program is coordinated by WIPO, and on behalf of the government, we have CIPAM and the National Judicial Academy of Bhopal. So the government of India has taken many steps, and they are hoping that they will be able to create a positive image. They will be able to create a positive image of Indian judiciary in the minds of foreign investors. Okay, the purpose should be very clear. Why are we passing these laws? Because we want to attract the foreign investment. We want to improve in the ease of doing business ranking. Okay, so what is the rank of India in the ease of doing business? Can anyone tell me? $141. No, Subhajit. It is in the 60s. No, I mean it is 63. Sridharan is right. And this ease of doing business ranking is released by World Bank. Okay, so India wants to improve its ranking in the ease of doing business, and for this reason, we are doing all these efforts, because Modi ji wants that the foreign companies, they should establish their base in India. Now this is IP Nani. IP Nani is basically the mascot. It is the mascot for IPR promotion. Okay, and this mascot was released in 2018 again by the Minister of Commerce. Okay, the minister in charge of commerce released this mascot in 2018 to promote the IPRs. Mascot meanings, mascot का meaning है हिंदी के अंदर शुभंकर. कुछ भी स्टार्ट करने से पहले anything or any person which brings good fortune. Okay, something which brings good fortune. It can be a thing, it can be a person. Okay, which will bring good luck. So mascot, it brings good luck. That is what is the meaning of mascot. Mascot means a thing or a person which brings you good fortune. Okay, man. Mascot is also being used as a type of branding, but the meaning of mascot is something or some person which brings good fortune. Okay. If you want to add anything else, you can add. Okay. So you have to remember this IP Nani. This was released by this SIPAM, Cell for IPR Promotion. Okay, and it is also under the Department for Promotion of Industry, DPIIT. So the government is working in this direction to improve the India's image. And this IP Nani, you can also go to its YouTube channel. She can brief you about the IPR issues. Okay, why the protection of intellectual property is important. She will tell you everything about it. You can go to her YouTube channel. So the question can be framed like IP Nani is related to the questions. They will be pretty simple usually. Okay, but because the syllabus of UPSC is so large that it is not very likely that you will retain it up till the examination. Okay, so generally this factual information, your memory is also an asset. If you can remember a lot of things, then prelims will be easier for you. And if you have amazing writing skills, okay, if you write amazing content, then mains will be easier for you. Okay. So who is this IP Nani? She is a tech savvy, smart, intelligent grandmother. Okay. And what she does, she helps the enforcement agencies like the police and the government. Okay. Against the crimes related to intellectual property. So what was the purpose of dispute resolution? On the basis of a proper legal framework, and the government of India is also ensuring other countries that we will not discriminate on the basis of nationality. Okay, the Indian laws, they will not discriminate on the basis of nationality of an innovator. If an innovator belongs to a different country, then Indian government assures them that no discrimination will happen. Okay, and we have a proper legal framework for it. So such kind of regime, such kind of intellectual property regime, it will instill confidence in the investors. So innovator will be more likely to invest in our country. That was the sole purpose, and it can bring in more investments. Okay, but at the same time, we have to protect the rights of the innovator, but we have also to protect the rights of the general public. So the government should not forget that they have to reach a balance between the rights of the innovator and the rights of the general public, the good of the general public. So now we are starting with the evergreening of patents. But before that, here is a diagram. We have the Office of Controller General of Patents, Design and Trademarks. This is with the Ministry of Commerce. And within this office, we have certain sub offices, like we have the patent office. Okay. Under the Office of Controller General of Patents, Designs and Trademarks, whose head office is in Mumbai. So the head office of the Office of Controller General of Patents, it is in Mumbai. And below this office, we also have a patent office whose headquarters is in Kolkata. We have a trademarks registry whose head office is in Mumbai. And we have the geographical indication registry, which is based in Chennai. And we have the copyrights registry, which is based in Delhi. If you can remember the headquarters, that is good. And if you cannot remember it, that is not an issue. Okay, your selection will not. Okay. So we have this design office headquartered in Kolkata, and this Rajiv Gandhi National Institute of Intellectual Property, it is in Nagpur. Such kind of factual information is always important. Yes, Sridharan. You want to ask something?
Sir, can you please explain the previous slide once again? The controller portion, sir. I didn't take down the notes of that.
This
The
one?
headquarters. No, sir. The headquarters part.
Okay. See, the headquarters of the Office of Controller General of Patents, it is in Mumbai. Trademark registry. It is basically semiconductors and integrated circuit. These circuits, they are also protected by these intellectual property rights. It is SCICLD, semiconductor and integrated circuits. Something related to it, okay? The electronic design or electronic circuits, they are also protected. They are also considered as innovation. So they are also protected by intellectual property rights. अगर सभी ने नोट कर लिया हो तो can we move on? So the parent ministry for all these offices is, the parent ministry is Ministry of Commerce. IP Nani, it was also launched by the Ministry of Commerce, this IPAM. Okay. So for the IPR matters, the Ministry of Commerce is the main ministry, the parent ministry. Now we are starting with the evergreening of patents. See, every time we cannot invent something new which the world has never seen. ऐसा नहीं हो सकता कि हम कुछ ऐसा हर बार ही क्रिएट कर पाएं कि दुनिया ने कभी ना देखा हो. Okay, so this thing is very, very tough. So innovator, what they do is they do some kind of tweaking. Tweaking means कुछ भी minor changes हमने कर दिए. So the innovators, they resort to this tweaking and they create new out of something old. Okay, and they call it a new invention. They have done some kind of tweaking with the old product and they have produced a new one. And they are saying to the world that, see, this is my new creation. Okay. So this task is quite easier. Every time you cannot create something which is new to the world. So that is the case for evergreening of patents, and it is mostly related to, this term is mostly related to pharma industry. Okay, pharmaceutical sector से ही ये related है. So by way of evergreening, there is no therapeutic advantage. Efficacy में कोई भी increase नहीं हो रहा है. In the case of pharma industry, efficacy में कोई भी वहां पे increment नहीं हो रहा है, कोई भी change नहीं होगा, लेकिन evergreening से कंपनी को इकोनॉमिक बेनिफिट्स होने वाले हैं, फाइनेंशियल बेनिफिट्स वो इनको जरूर होंगे. And yesterday Aman has asked a very good question and he is typing something again. Yes, Aman, go ahead.
सर मैं कह रहा था कि कल आपने बोला था कि कोई थेरेपेटिक चेंज होना चाहिए अगर आपको उसकी
जी
ऑर्डर लेने के लिए.
जी.
आफ्टर 20 इयर्स जो आपको पेटेंट की एवरग्रीनिंग करानी है तो उसके लिए आपको थेरेपेटिक चेंज होना जरूरी है.
See, 20 इयर्स के बाद जो पेटेंट के राइट्स हैं वो खत्म हो जाएंगे, उसके बाद वो उसको नए प्रोडक्ट की तरह रजिस्टर करा रहे हैं.
आपने बोला था ना कि पर उसके लिए कोई ना कोई एडिशनल थेरेपेटिक एडवांटेज होनी चाहिए.
हाँ, ये अभी मैं इसके ऊपर आता हूँ, थोड़ा वेट करो. आई होप ऑल योर डाउट्स विल क्लियर. सो इन द इंडियन पेटेंट एक्ट, अभी हमने इंडियन पेटेंट एक्ट की बात की थी. इंडियन पेटेंट एक्ट ऑफ 1970 देयर इज अ सेक्शन 3D. सेक्शन 3D न्यूज के अंदर बहुत ज्यादा रहा है. सो अंडर दिस सेक्शन 3D, दिस वाज इंसर्टेड इन 2005 and in the developing world, this section 3D of the Indian Patent Act, this section is itself considered as an innovation. Innovation in the field of law. So developing countries, they treat this section as some kind of innovation in the field of law, in the patent law. Okay, and we will see it soon why they call it so. And after that, after 2013, many developing countries, they have copied this, they have emulated this law. Okay, into their, they have incorporated this provision in their laws as well. Okay, so this section 3D of the Indian Patent Act 1970, it requires the innovator to submit the evidence, of the increased therapeutic effect, okay, of the increased efficacy of the drugs. So by virtue of this section, the innovator, he has to prove it that my new drug, it will be more beneficial, it will have certain increased efficacy in the patients. Okay, so this act acts as a safeguard for the public health. Okay, and the quality of patents is related to the access to medicines. So this act basically is based on this philosophy. Okay, you cannot grant patent to any other medicine because the quality of patents is related to the access to medicines. So we are very choosy while granting the patents. Can we take example of paracetamol? Well, Nikhil, I cannot say anything about it because paracetamol is available very freely in the market. All your doubts will clear. Just wait. Because the quality of patents, it is related to the access to the medicines, access to the general public, the good of the general public. Okay, it is linked to the access to the medicines. So we cannot grant patents to any other thing. That is why the Indian government, the parliament has incorporated this section 3D in the law. And as per this section, the innovator has to provide evidence for the increased efficacy of the medicine. Okay, and even they have mentioned in this act like mere changing of the chemical formulas or changing of the polymer chains. Okay, you cannot. Yes, Vipul.
No, sir, it's a technical glitch.
Okay, okay. So where was I? So we cannot grant patents to any other thing. That was the point. And if any company comes to the patent office and they say that we have a new medicine now with the increased efficacy, then they have to prove it. They have to prove that it has something different from the earlier medicines and it will impact the patients positively. Merely changing a chemical formula or the composition, or by using a different chain of molecules, different polymers, okay, if the medicine has the same effect, then there is no point in granting the patent. जनरली कंपनीज क्या करती थी, कॉम्पोजिशन में थोड़ा वेरिएशन किया या पॉलीमर्स थोड़े से चेंज कर दिए, कंपाउंड्स थोड़े से डिफरेंट उन्होंने कर दिए, लेकिन उसका अल्टीमेट इंपैक्ट पेशेंट की बॉडी पे सेम ही है. उनका मेन पर्पस था दोबारा से पेटेंट लेने का. तो इस चीज को एवरग्रीनिंग ऑफ पेटेंट बोलते थे. इंडियन लॉ के अकॉर्डिंग अगर आपकी दवाई की एफिशिएंसी इंक्रीज हुई है तो ही हम आपको पेटेंट ग्रांट करेंगे. दिस वाज द पॉइंट ऑफ दिस एक्ट, दिस पर्टिकुलर सेक्शन.
So
Yes,
I didn't get the last line.
So the quality of patents is linked to access to medicines.
Yes, sir.
See, the quality of patent means if there is not some new innovation, because in the case of cancer, access to the cancer drug is very important for the general public. Okay.
Yes.
And if there is a new cancer drug in the market, in which we have done only the minor changes. Okay. And we want patent for that. Once a medicine gets patented, it will be very difficult to get its generic version.
Yes.
I will come to your point. You asked a very good question yesterday. I will come to that, and all your doubts will clear. So there was this case study. See, there is a company Novartis, and it is based in Basel. Can anyone tell me where is Basel?
You are now unmuted.
No, Basel is in Switzerland, not in Netherlands. So we have this cancer drug by the pharma company Novartis by the name of Gleivec. Okay, this Gleivec is the cancer drug. So they applied for the patent at the Indian Patent Office. The Indian Patent Office, they rejected their application by invoking the section 3D. सेक्शन 3D की भी मैंने बात की थी. सेक्शन 3D का इन्होंने यूज करके इनको पेटेंट देने से मना कर दिया, बिकॉज देयर वाज नथिंग न्यू इन दिस ग्लाइवेक, दैट वाज देयर ओल्ड कैंसर ड्रग. सो IPO रिजेक्टेड ग्रांटिंग पेटेंट टू द नोवार्टिस. अब इसके बाद में नोवार्टिस चली गई मद्रास हाई कोर्ट में. तो मद्रास हाई कोर्ट इट आल्सो अपहेल्ड द डिसीजन टेकन बाय इंडियन पेटेंट ऑफिस. उसके बाद में इंटेलेक्चुअल प्रॉपर्टी एपेलेट बोर्ड के पास जब ये मैटर गया तो वहां भी इसको अपहोल्ड कर दिया गया, एंड फाइनली मैटर फिर सुप्रीम कोर्ट के पास गया. एंड इन 2013, अब सुप्रीम कोर्ट से ऊपर इंडिया में कुछ भी नहीं है. एक बार सुप्रीम कोर्ट ने जो डिसीजन ले लिया फिर वो फाइनल है. ओके, लाइक इन द केस ऑफ द राम टेम्पल, व्हेन द सुप्रीम कोर्ट हैज गिवन द मेजॉरिटी जजमेंट, तो उसके बाद फिर अब कुछ बैरियर ही नहीं बचा था, इसलिए राम मंदिर बनाना इजी हो गया. तो सेम इज द केस हियर. इन 2013 the Supreme Court upheld the constitutional validity of section 3D. That section 3D is constitutionally valid and Indian Patent Office has acted wisely. So they rejected the claim of Novartis. So this judgment, and the section 3D of India, it was held in the developing world. While in the developed world, they resented this, that Indian Supreme Court has not acted wisely. So the pharmaceutical companies, the foreign pharmaceutical companies, they also denounced this judgment. But this judgment has wider connotations for the general public, for the interest of general public. Okay. So Supreme Court upheld the constitutional validity of the section 3D, using which we denied the evergreening of patent to this Novartis, the drug of Novartis, Glyvac. See what happens. The company is involved in research and development for many years. Okay, a pharma company, it is involved in research and development, and this research and development procedure, it is, you are not sure that you will be successful in it. Now understand it like that. Now we are discovering some kind of medicine for some vaccine for the COVID-19. So research and development on the COVID-19 is going on, and a company, when it pours in money in the research and development, we are not sure that we will be able to have any positive outcome. Okay, so lot of risks are involved. There are a lot of risks involved. We are not sure that we will be successful. So research and development में बहुत सारा पैसा यहाँ पे खर्च होता है. And finally, if you have discovered a formula, then there will be trials. Okay, and after the trials, finally the drug is released in the market. And as soon as the drug is released in the market, the company applies for the patent for the exclusive monopolistic rights. Okay. So the idea of having the patents is also this, since they were involved with huge risks. Research and development, it involved huge risks, and they have done the clinical trials for it, and the process was long. It takes at least 4 or 5 years, and even more than that. So the patents are generally awarded for the research and development, and the exclusive rights, they go on for 20 years. And the government assumed that within this 20-year period, the company, it will recover all its cost, and it will also be able to make huge profit out of it. Okay, but after the period ends, after the 20 years, the generic medicine manufacturers, they now come to the market, and they now prepare the same drug, and this is the generic version of the same drugs. It becomes available in the market. Okay, so yesterday Aman raised a very good question that कि सर जब अब नया प्रोडक्ट लॉन्च कर दिया तो पुरानी वाली के लिए तो पेटेंट बचा ही नहीं, उसके लिए तो जेनेरिक वर्जन आ सकता है, कंपनी को फायदा क्या होगा? Aman, that was your question. So here the companies, the argument given by the companies is that evergreening for them is a necessity. When they did not get the judgment in their favor, they put the argument like this, that evergreening of the patents is a necessity, because if they do not resort to the evergreening, they will lose their market. They say that if they will lose their market, then they will not have enough fund to invest in R&D, and for this purpose, they need this evergreening of patent to maintain their market. So this argument is it does not have much ground. And then their other argument is that the doctors are free and they can still prescribe the generic version of the older product. Okay, that point is also made by them, and that point was also made by Aman. That was a very good question. But now the companies, what they do is, the companies, they have huge resources, they have huge funds. So what they do, they pour in a lot of money. They pour in a lot of money into the advertisement and marketing of the new product. Okay, and their marketing, it is designed in such a way, they design their marketing in such a way that the doctors, they start to prescribe the new drug. Instead of prescribing the old drug, they start to prescribe the new drug. तो अपने जितना भी इनके पास पैसा है, रिसोर्सेज है, उनका यूज करके टारगेटेड मार्केटिंग करते हैं, टारगेटेड एडवर्टीजमेंट जिस भी तरीके से करते हैं कि दैट डॉक्टर्स नाउ स्टार्ट टू प्रेस्क्राइब दीज न्यू ड्रग्स. So that is why the market demand for the new drug increases in the market, okay, and the demand for the older product reduces, and a notion develops that the older product does not have that much efficacy. So they are primarily targeting the doctors, and they know their skill. They are sure, they are confident of their marketing skills, that we will be able to generate a demand for our new product. The old product, it will not capture much of their market. Okay, so their marketing strategies are devised in such a way. I hope, Aman, now your doubt is clear. Okay, so that was the whole argument. So Indian patent law, it is the anti-evergreening law. And I am giving you a task. In the next class, you will tell me that which developing countries, they have incorporated some clause like section 3D in their IPR laws. Okay, so in the next class, I will ask you this question and you will tell me which countries have incorporated section 3D like clause in their laws. Okay, now we have this intellectual property appellate board. See, this intellectual property appellate board, I told you that in 2013, the Supreme Court passed a judgment against the Novartis. So after the Madras High Court, the matter went to this intellectual property appellate board, and after that, it went on to the Supreme Court. So this intellectual property appellate board, it was established by Section 83 of the Trademarks Act. Now this factual information, it becomes important from the prelims point of view. Okay, it has no relevance for the mains. In mains, they will check your understanding of the topics. Okay, they will check the understanding of the evergreening of the patents. What consequences will the evergreening have on the Indian pharmaceutical sector? But such kind of information, they can come in MCQs. The question is, I told you that in section 3D, section 3D is basically the anti-evergreening law. And after seeing this section in the Indian law and the work of this section against the evergreening of patent, some developing countries have incorporated such a clause in their laws. Okay, a clause like section 3D, they have incorporated it in their laws. So which developing countries have done it? That was the question. Okay, Disha.
You are now unmuted.
Okay, so this intellectual property appellate board, it was established by the Trademark Act. A prelims point of view से ये याद करने वाली चीज है, जिसकी मेमोरी जितना ज्यादा रिटेन कर सकती है उतना ज्यादा एडवांटेज है. Okay, so this appellate board, it was established by central government by a notification, okay, on 15 September 2003. So Trademarks Act के अंदर एक clause डाल दिया होगा कि सेंट्रल गवर्नमेंट कैन एस्टैब्लिश एन इंटेलेक्चुअल प्रॉपर्टी एपेलेट बोर्ड, और उसके बाद सेंट्रल गवर्नमेंट ने एक नोटिफिकेशन पास की 2003 में. उस नोटिफिकेशन के बाद से इंटेलेक्चुअल प्रॉपर्टी एपेलेट बोर्ड एस्टैब्लिश हो गया. लेकिन स्टार्टिंग में इट वाज एस्टैब्लिश्ड टू डील विद ओनली द ट्रेडमार्क्स, बट लेटर ऑन इट now hears the appeals for the trademarks, for the copyrights, for the patents, and for geographical indications as well. Okay, if you have any doubt up till now, you can ask me. Okay, and still if anyone has any doubts, you can send your doubts to Jitin sir. Okay, we are available for you 24/7, and we will try to answer all your doubts within 12-hour time. Okay, obviously we cannot answer your queries at 2 p.m. in the night, but we will try to any book. See, for the science and technology, we cannot suggest you any book that are available in the market, and we suggest you that NCRTs plus newspapers, okay, they are the best. NCRTs plus newspaper. And if you can read the 10th class NCRT for science and tech, that will be very helpful, okay. And the newspapers, they will help you. The material provided by the institute, rest all other books that you will get in the market, they are not as good. They are just the copy of one another. So the material that we will provide you in the class and the material